Okay, I think we'll go ahead and get started now. Welcome to the final session of the Optum Idaho Annual Conference. I would like to take the opportunity to introduce the two speakers that have been gracious enough to join us today for your ethics conversation. Kim Stanger is a partner in the Boise, Idaho office of Holland & Hart LLP and the chair of the firm's health law group. Kim helps clients navigate the complex state and federal regulations governing the healthcare industry, including healthcare reform, fraud, and abuse laws. That also includes HIPAA and EMTALA, Medicare/Medicaid regulations, licensing requirements, compliance and administrative proceedings, and litigation. Complementing Mr. Stanger's presentation today is Ms. Ali Schellender. Ali helps healthcare clients navigate regulatory and compliance matters with an emphasis on assessing regulatory risks and impacts on transactions and M&A activity. She assists buyers, sellers, and operators in the healthcare industry with federal and state regulatory compliance, including physician referral laws, or that should be self-referral laws, such as Stark anti-kickback statutes, civil monetary penalties laws, antitrust, and licensing. She also counsels providers, facilities, and affiliated entities on matters related to Medicare and Medicaid programs. And just before I turn it loose, I would like to remind you that when we do have questions from the audience, Mr. Stanger has said go ahead and ask them or request to have a microphone when you'd like to ask them. But don't ask your question until you have a microphone, because those folks joining us online are unable to hear your questions. So, with no further ado, Mr. Stanger.
All right. Thank you very much. Well, boy, what a way to end up the day, listen to a bunch of lawyers. I do want to thank you guys, though. I represent all kinds of healthcare providers, and without a doubt, you guys have got the toughest job out there in healthcare. I don't know anybody who faces the problems that you guys do on a daily basis. In fact, I'll be honest with you, I had a daughter who wanted to go into social work, and I told her to think long and hard, because I've got to think that's got to be a tough row to hoe, and at the end of the day, you're probably just exhausted emotionally and physically and every other way. So I really do thank you, and I pay tribute to you. If I were as good as you, I would have done social work, but instead I became a lawyer. All right, so they gave me a lot of things to cover today, especially consent and confidentiality. So we're going to do our best to cover those and everything else that's on this list as quickly as we can. But as we go along, as Dennis said, if you've got questions, feel free to go ahead and raise them. Quite frankly, it's more fun for me if you ask questions. It keeps me from falling asleep at my own words. So let's talk first. And because we are going to be going through a lot of this stuff so quickly, I've given you resources in the written materials, a lot of articles that I've written, because I basically have no life. And so other people play golf, I write articles. So I've got a bunch of articles that go into, I think, everything that we're going to talk about today that goes into more detail. So if I don't cover everything, you need some kind of written resources. There you go. All right, let's start by talking with informed consent. General principles of informed consent. No surprise to you guys. You got to get informed consent, right? So you must have the patient's consent before you go ahead and provide care. In addition, in order for that consent to be effective, the patient has to have sufficient capacity to give that consent, right? If they don't have capacity, the consent's not effective. If the patient lacks capacity, then you got to make sure that you get consent from an authorized surrogate, somebody else who has authority under the law who can give that consent. And finally, in order for that consent to be effective, it's got to be informed consent, because if it's not informed, it's really not effective consent. Now, what happens if you fail to get informed consent? Well, any number of bad things. You could get an adverse licensure action, or the patient could sue you, perhaps for malpractice, for assault or battery, depending on what's going on. Mental health care providers, well, you're probably not going to be doing a lot of touching with this person, so maybe no assault or battery, but maybe they could get you for negligent infliction of emotional distress or whatever. In addition, Idaho actually has a separate tort. A tort is not a cake. It's what we call in legal terms, it's a cause of action, a private cause of action. Okay, they have a private cause of action for lack of informed consent. So even though they may not suffer any physical damage, they could still sue you and recover some form of damages just simply because you didn't get informed consent. Now, the beauty of it, informed consent is a defense to all of those things, right? So if you get appropriate informed consent, then you're going to be protected. So let's talk about the things that you need in order to have informed consent. Idaho actually has a statute concerning informed consent. So this is the statute, right? You want to know whether or not the person can give effective consent? This is the standard. The standard says any person, note that it says any person. I'm going to come back to that in just a minute. Any person who comprehends the need for, the nature of, and the significant risks ordinarily inherent in any contemplated healthcare treatment or procedure is competent to consent thereto or refuse on his or her own behalf. You want to know what the standard is? That's the standard. Whether or not that person has sufficient capacity, that's the standard. Who makes that determination about whether they have sufficient capacity? Well, you guys do. The very next section goes on to say, any healthcare provider may provide such healthcare and services in reliance upon such a consent if the consenting person appears to the healthcare provider, you guys, securing the consent to possess such requisite comprehension at the time of giving consent. Okay, that's the standard for determining whether or not that patient has sufficient capacity to consent on their own behalf or refuse healthcare on their own behalf. Well, what happens if the patient lacks capacity? Well, the very next section goes on to state that if the consent for the furnishing of healthcare to any person who is not then capable of giving such consent or who is a minor may be given or refused by the following persons. Now remember earlier I said any person? This statute says any person can consent to their own healthcare assuming that they have sufficient understanding and comprehension. Does that say any minor or any adult? No, it says any person. But the very next section says, but in the case of minors, these are the people who can consent on behalf of the minor. So the conservative approach is to assume that minors can't consent to their own health care unless an exception applies. We'll talk about that in just a minute. So if you've got a person who lacks capacity, who can consent on their own behalf? Idaho, we have this hierarchy, right? You start at the top, you go to the bottom. So if the patient lacks capacity or is a minor, you would get consent from first the court-appointed guardian. And by the way, that's a court-appointed guardian. That's not just a parent. A parent may be a guardian, but they're not a court-appointed guardian. So the very top, it's court-appointed guardian. If there's no court-appointed guardian, then it would be the person that's named in the living will or durable power of attorney. If that's been triggered, if there's none of that, then it would be the spouse. If there's no spouse, then it would be an adult child. If there's no adult child, then it would be a parent. If there's no parent, then it could be somebody in a delegation of parental authority. That's a document that if you're going to leave town and you want your neighbor to take care of your son or daughter, you can fill out this delegation of parental authority and give them the decision. If there's none of that, then any other appropriate relative can consent on their own behalf. Who's an appropriate relative? Well, we didn't define that when we amended the statute. Could be aunt, could be uncle, could be adult sibling, could be cousin twice removed, who knows, right? It just says any other appropriate relative. And if you haven't got that person, then any other competent person representing himself or herself to be responsible for the health care. Okay? Who might that be? Could be a coach, could be a babysitter, could be somebody else like that, right? The key here, though, is that you start at the top and you come down, right? So if the parent's available or the spouse is available, you don't go anybody below that, right? So you start at the top and you come down. That's the way that works. Now, if there's none of these people that are available and it's an emergency situation, you can go ahead and provide care for an emergency as if you had appropriate informed consent. You just want to make sure that you contact the people who have that authority in the meantime. So let's talk about minors now, because that's where this usually comes up in the context of minors. So in the case of minors, the conservative approach, because of the way that those statutes are written, is to assume that a minor cannot consent to their own health care unless they fit within an exception. What are those exceptions under Idaho law? Well, if they're emancipated, or if there's a statute that allows the minor to consent, or if there's a statute that basically says you can provide care even if nobody consents. There is something called the mature minor doctrine, which basically says, look, there's no magic about that 18th birthday, right? It's not like the wisdom fairy comes in and touches the kid on their birthday, the night before the birthday, and they suddenly get wise. The mature minor doctrine says, look, if the kid has sufficient capacity to understand and appreciate the consequences of what they're doing, they ought to be able to make their own decisions. The problem is in Idaho, we haven't got any court decisions that establish that mature minor doctrine. And so we've got this, instead we've got this statute that says in the case of minors, these are the people who can consent to their own health care. So if you're going to rely on that mature minor doctrine, you'll probably be okay. But the more significant the treatment that you're providing, the more important it is probably for you to get the parental consent just to make sure that you're going to be safe. Let's talk about some of those exceptions then. What are emancipating events in Idaho? Well, we think these are the emancipating events when it comes to minors. If they are married or have ever been married, if they are serving in the armed forces, if they are living on their own and self-sufficient, otherwise have rejected the parent-child relationship, they are truly on their own, then the law wants to allow them to make their own decisions. Otherwise, who's going to make their decisions, right? Or if the court declares them to be emancipated. So if they're emancipated, they can generally make their own decisions. Now, even if they're emancipated, remember, you still got to go back to that fundamental test. They still have to comprehend the need for, the nature of, and the significant risks, right? They still have to satisfy that criteria before they can consent to their own health care, even though they're emancipated. All right, now in Idaho, we have certain statutes that allow minors to go ahead and consent to their own health care. For example, if they show up at the hospital emergency room, then EMTALA would allow them to consent, or at least for the initiation of the care, for contraceptives. As long as they have sufficient capacity or sufficient maturity, then a healthcare provider can talk to them about contraceptives, despite what the U of I might think. Family planning services, under a federal statute, the minor can consent to their own family planning services under Title 10. Drug treatment or rehab, age 14 testing or treatment, for infectious or communicable diseases, age 17, unpaid blood donations. But let's get to the sticky wicket. What about mental health care? Can minors consent to their own mental health care in Idaho? Well, the problem is, at least I've only been able to find a couple of statutes addressing this. And the problem is, the statutes all arise in the context of hospitalization for mental illness, not just the provision of mental health care. It's in the context of hospitalization. The statute specifically says, the director of any facility or a practitioner granted admitting privileges may admit as a voluntary patient, blah, 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 blah. We'll come back to that in just a minute. But it is the director of any facility or practitioner granted admitting privileges at that facility. Well, then the question is, okay, what's a facility? Well, in the statute, facility means any public or private hospital, state hospital, institution, mental health center, or other organization. Well, that covers pretty much everybody, right? Designated in accordance with the rules adopted by the Board of Health and Welfare as equipped to initially hold, evaluate, rehabilitate, or provide care or treatment or both for mentally ill. So if you are just a solo practitioner that's out there kind of on your own, do you fit within this mental health center? Are you an organization that's been approved by regulations from health and welfare to initially rehabilitate or provide care or treatment or both to mentally ill? I don't know. I haven't been able to find any decisions or any regulations discussing that. So that puts you in a bit of a bind, right? So let's go on. So first of all, you've got to be at a facility or mental health, it only applies if you're at a facility or a practitioner granted privileges at that facility. It all talks in the context of admissions. So if you're at one of those facilities, any individual age 14 to 18 years of age may apply to be admitted for observation, diagnosis, evaluation, care, or treatment at the facility. And the director will notify the parents or guardian of the individual or admission. Any emancipated minor can go ahead and apply to get admitted. The key there is, though, if you're age 14 to 18, apparently you can go. You can apply to get hospitalized, but could you go to see your own mental health counselor? It's a little bit inconsistent, right? Well, we'll allow you to admit yourself to be hospitalized, but we're not going to let you go get your own treatment outside of a hospital setting. But unfortunately, we don't have any statutes that really clarify that, and I'm not aware of any cases that decide that particular issue. We do know that in the Department of Health and Welfare's Children's Mental Health Services, they generally say that they've got to get parental consent in order to provide those mental health services from the state. So the bottom line here for mental health care providers, if I were you, I think that the safest approach is to assume that minors can't consent to their own health care. If you're going to allow them to consent to their own health care based on this, you may be okay. A court may side with you. It's just we haven't got real clear statutory protection for you in that case. Nothing clear in the statutes to say that they can consent on their own behalf in that situation. It's maybe something to talk to your legislators about. All right. There are some statutes that also allow you to go ahead and provide care to minors, even if the minor doesn't consent, because it doesn't require consent. These are situations, particularly emergency situations, where the authorized surrogate's not available. You can go ahead and provide care. Also, mental holds at hospitals. If the patient shows up at a hospital and the person is gravely disabled or poses a substantial risk to themselves or to somebody else, then a physician or advanced practice professional at the hospital can go ahead and initiate a mental hold and go ahead and provide that care and treatment while they go through the designated health or the designated exam. Similar for minors, if a police officer or the minor shows up at a police officer brings a child to a hospital, then they can go through the shelter care process. If the child suffers from an emergency condition resulting from a severe emotional distress situation. But even in that situation, the parents can refuse the treatment. If the parents refuse the treatment, then the hospital can call the police long enough to see if the police want to initiate a hold and take the patient to some kind of inpatient situation. That actually suggests, again, that maybe minors can't consent to their own health care in most cases. All right, so that's the capacity issue, minors in those situations. What about the form of consent? In order for the consent to be effective, does it have to be written? Do you have to have a written informed consent or a consent form in order for it to be effective? No, the Idaho statute specifically says it is not essential to the validity of any consent that the consent be in writing or any other specific form of expression. But as lawyers, do we like it in writing? You bet we do, partly because the statute itself says that if you do get it in writing, that it is presumptively valid, okay? Now, that doesn't mean that it couldn't be overcome, but it's presumptively valid, and therefore we like the informed consent, written informed consent. Now, for some of you, depending on your licensure, there may be other laws or regulations that require some kind of a written consent. I know for social workers, they've got a list of things that actually they want a written informed consent. There's a whole bunch of things that have to be in your informed consent, right? That's not the general rule, but so you might want to check with your particular licensing entity. Really important point. Informed consent is not a consent form. They are two separate things. Informed consent is communication. Consent form is documentation, hopefully, that the communication took place. In order to have informed consent, you have to have understanding. You have to explain the relevant risks and the benefits to the patient. The patient has to understand it, and then they have to agree to get the treatment. Okay? That's informed consent, right? A consent form is nothing more than they sign a paper, right, documenting, hopefully, that informed consent communication took place. Just handing the patient a consent form may not mean that they really got informed consent, especially if they're Hispanic and the consent form's written in English, or maybe they're traumatized, or maybe they're not in a situation where they can really understand. In those situations, that's not informed consent, just handing them a consent form. You can use consent forms, but they should be used to supplement and document that the informed consent occurred. But you should never substitute informed consent by a consent form. Now, who's responsible, or what needs to be in that consent in order to make sure that it's valid? We already said, right? You have to provide sufficient information so that they understand. What kind of information do you need to give them? Well, again, the Idaho statute specifically says, consent or refusal to consent for the furnishing of health care shall be valid in all respects if the person giving or refusing the consent is sufficiently aware of the pertinent facts respecting to, these are the three things that you got to make sure the patient understands. The need for, the nature of, and the significant risks ordinarily attendant upon such a person receiving such care as to permit the giving or withholding of such consent to be a reasonably informed decision. That's the general standard. It's possible, again, like for social workers, you may need to provide additional information, but that's the statutory standard. Make sure you're familiar with any particular licensing rules that may also apply. Well, who makes that determination? Is it subjective? Does the patient make that determination of what information they wanted to get? And could they sue you if you didn't give them the information they thought they wanted? Not under the statute. The statute says that it's an objective test. You're going to be measured by the information that would ordinarily be made or given under the similar circumstances by a like healthcare provider of good standing practicing in the same community. So it's an objective standard, kind of like the standard of care, right? They look at, okay, what would another similar licensed practitioner in my field, what information would they provide to their patients in order to make sure that the patient could make an informed decision? That's the standard, absent any other particular licensing regulations that may apply in your situation. Who's responsible for getting that consent? Well, it's the nurse, because the nurse has to do everything, right? It's actually the statute. When we amended a while ago, we made it clear that no, it's the treating provider. It's the provider at whose direction the care is being rendered. They're the ones who are responsible for making sure that informed consent is obtained. Why? Because they're the one got the license, right? They're the ones who are making the decisions. They're the ones who have the ability to answer questions and provide the information. They're ultimately responsible for ensuring that informed consent is obtained. Now, they can use other people to help them secure that informed consent, but the buck stops with that licensed provider. They're responsible for ensuring that gets done. Okay, those are the general rules concerning informed consent. Remember, though, that informed consent, the flip side of informed consent is informed refusal. If a patient has the right to consent, they also have the right to refuse care, as long as they have sufficient capacity to make that decision. Yes, question?
We have a question online that's asking, how does the consent work if a parent wants and consents to a child between the age of 14 and 18 to receive mental health treatment? However, the child refuses the consent.
Okay, so I'm not sure whether everybody heard that, but what do you do in a situation if the parent wants the kid to get it, kids between 14 to 18 to get it, and the kid refuses to get it?
Right.
The practical response is I'd be really nervous about providing the care if the kid's going to object and I don't know how effective you can be in providing the care. From the legal standpoint, though, if the kid hasn't got capacity to make his own decisions, they can't make the decision to consent or refuse. So the parent would have that authority to go ahead and make that decision. Now, outside of the hospitalization, right? The hospitalization, a kid who's 14 to 18 can consent to their own hospitalization for mental health care if they want to. So they could probably refuse, arguably they might refuse in that situation too. So I guess the bottom line is, as a legal matter outside of the hospitalization context, I think that you could probably rely on the parents' direction to go ahead and provide that care. Now, whether or not that would be effective care and whether or not you want to do that is a whole nother question. And the big issue there is, remember that you guys aren't required to take all comers, right? Unless you're at a hospital with EMTALA, you can decide whether or not you want to provide that care. And if it's not an appropriate situation, you could tell them, look, come back to us once these issues are resolved. So, all right, is that okay? You okay with that?
I think so.
Dennis says he's okay with that. All right, another question.
What about divorce cases?
Oh.
One of the things I have a problem with is if we take our child to the doctors and the other parent isn't there because it's divorced, they don't ask us to get the consent of the other parent. They treat our child.
Well, that's all theoretical, because there's no divorced couple that ever disagree, is there? Yeah, this is a common problem that comes up. But if you look at the statute, going way back here, those people who have authority, it says that you can provide the care based on the consent of one of the following persons, including a parent, right? So you would just have to get one, and I think that you would be okay. I haven't seen any cases. Now, again, though, I would go back to kind of what we talked about earlier. In those situations, if it's not emergent care, urgent care, I would probably tell the parents, look, you guys go ahead, you guys figure this out yourselves and come back when you're in agreement, and then I'll go ahead and provide the care, so that you don't get caught in the middle of them. If it were an emergent situation, though, and you felt like you really wanted to do that, I would probably tell the parent who is objecting, look, if this kid really needs the care, I've got the consent of one of the parents, that's all I needed under the statute. If you don't like it, then you can go to court and you can get some kind of an order or go get some kind of temporary custody or whatever. I really think you'll be okay, but I would try to avoid getting in that situation by just simply saying, look, you guys go work it out and come back to me once you're on the same page. Okay? All right, any other questions about those consent issues?
Yeah. We have another one online. Bevan says, I hope the presenter covers client's age and confidentiality. What age does the adolescent hold the privilege?
That is a terrific segue into patient confidentiality. Devin and I worked this out in advance. Okay. All right. So if there's no more questions again about patient consent, I'll roll right into the confidentiality issues. When we're talking about confidentiality, just remember this. There are a bunch of laws out there, and they don't always fit together really, really well. But we now have HIPAA, and HIPAA is the floor of patient privacy. It's a federal law, so it preempts contrary state law. So to the extent, you've got to comply with at least HIPAA, okay? To the extent that there's another law that is more restrictive than HIPAA, then you've got to comply with the other law. Another law that is either provides greater protection to the patient for their records or their information, or another law that provides the patient greater rights concerning their own information. Then HIPAA would say, no, you got to comply with that other law. So for example, you've got to be concerned about HIPAA, assuming that you are a healthcare provider who's engaging in certain electronic transactions. Did you know HIPAA doesn't apply to all healthcare providers? It's only healthcare providers who engage in certain electronic transactions. If you're if you are a dinosaur living without any kind of computers and you're completely off the grid, okay, no electronic transactions, HIPAA doesn't apply to you, okay? But that's not many of us these days. So if you're engaging in those electronic transactions and you're covered by HIPAA, then you've got to comply with at least HIPAA. To the extent there's another law that is more restrictive, you have to comply with the more restrictive law. So for example, 42 CFR Part 2. How many of you are affiliated with a federally assisted substance use disorder program? Any of you? I feel sorry for you, okay? But for those of you who are, you've got to not only comply with HIPAA, but you also got to comply with 42 CFR Part 2, which in some respects is more restrictive than HIPAA, okay? Some states have additional requirements for like AIDS. Some have additional requirements for mental health care. Idaho, we really don't. There are general statements in the licensing regulations that say you can't disclose information without the patient's consent, but at least in my discussions with the regulators, they interpret that to mean if you comply with HIPAA, then you're okay under the state regulations, although I've never seen anything from them recently. So you got to comply with the most restrictive law. So let's talk about the HIPAA issues, okay? What happens if you fail to comply with HIPAA? Well, a bunch of bad things, or 42 CFR Part 2. Under HIPAA, well, let me back up. For those of you who are with federally assisted substance use disorder programs, the CARES Act from 2021 amended the 42 CFR Part 2 so that now it coordinates a lot better with HIPAA. It used to be that you were subject to criminal penalties if you violated Part 2. They threw that out and they said now it's just you're subject to the HIPAA penalties. If there's a breach, you have to report just like you would under HIPAA. So it kind of coordinates more with HIPAA now. So what are the penalties if you violate it? Well, you can get up with civil penalties. I'll talk about that in a minute. In addition, you can get up, did you know you can actually go to jail for HIPAA violations? There's actually a criminal statute for HIPAA violations. You've got to affirmatively narc on yourself if there's a breach of protected health information. We'll talk more about that in a minute. Even if you're not worried about the government coming after you, your employer would have to take adverse action against you, impose sanctions, otherwise they're violating HIPAA. The Attorney General could actually come after you for a HIPAA violation. And coming soon, there's a provision under the Omnibus Rule, when they enacted the Omnibus Rule, the High-Tech Act, which basically said that right now, if penalties are imposed against you or you settle a case, then the patient who brings those claims against you is entitled to a percentage of those, okay, or a portion of those. Now, we never got the implementing regulations, so we haven't really worried about that. But this year, HHS published a request for information indicating that, okay, the time has come. So pretty soon, we're going to see a situation that patients now, if there are HIPAA penalties imposed, those patients are going to get a percentage of those fines or penalties or some portion of that, which of course is going to turn them into bounty hunters. And if you tick them off, they may want to turn you in for HIPAA violations, just if nothing else, so that they can pay for their next vacation. Okay, so watch out for that coming down the road. Those are the HIPAA fines and penalties. In addition to that, you could also be hit up with, adverse licensure actions, lawsuits by the patient, anything else like that. Well, let's talk about the HIPAA penalties. HIPAA's got a tiered structure. These are the penalties that can apply to you for HIPAA violations. If you did not know and should not have known of the violation, anywhere from $127 to $64,000. If the violation was due to reasonable cause, $1,200 to $64,000. That's bad enough. The good news on those is that if you don't act with willful neglect, you're in those first two categories, and you correct the situation within 30 days, no HIPAA penalties. That's an affirmative defense to HIPAA penalties. The bad news is, though, if you do act with willful neglect, then it's a mandatory penalty. The OCR must impose penalties against you of about $13,000 to $64,000 per violation. That's if you correct it within 30 days. If you don't correct it within 30 days because you don't like HIPAA or the horse it rode in on, well, in that case, willful neglect, you don't collect, it's a mandatory penalty of $64,000 to $2 million per violation. And by the way, let's say you've got an unencrypted laptop, and that unencrypted laptop is stolen, and you've got information of 1,000 patients on that laptop. How many violations is that? It's 1,000. Not only that, but because encryption is one of the addressable standards, a presumptive standard that you had to comply with under the security rule, for every day you didn't have that thing properly encrypted, guess what? That's another violation. So the penalties can add up there very quickly. The key there is to make sure that you're not acting with willful neglect, because in that case, you can avoid HIPAA penalties. So what do you need to do to make sure you don't act with willful neglect? Well, you need to make sure that you've got the required policies and safeguards in place, those policies that are required by HIPAA. You need to make sure that you execute appropriate business associate agreements with those business associates with whom you share information. Do you guys know who business associates are? What business associates are? Anybody? Bueller? Bueller? Okay, I'll come back. There we go. Okay, we'll come back and talk about that in just a minute. You need to train your personnel about the HIPAA stuff. This is an important one because in the commentary that accompanied the omnibus rule, the government said, hey, if you've got a rogue employee who just goes out there and shares the information improperly, as long as you had the appropriate policies in place and you provided the appropriate training and you respond immediately to correct any situation, guess what? That's not willful neglect on your part. It may be on his part, but it's not your part. And therefore, if you correct the situation within 30 days, no willful neglect, therefore, no penalties, okay? And you need to make sure that you timely report the breaches if required. So those are the general things you need to do to make sure you avoid HIPAA penalties. Let's talk about some of the rules, the use and disclosure rules. Hopefully you all know this already. General rule under HIPAA is you cannot use or disclose any of the patient's protected health information unless you've got the patient's authorization or you fit within an exception. Now remember that you can't only disclose it outside, you can't even use it internally, okay? Unless you've got the patient's authorization or you fit within an appropriate exception. And remember when we're talking about HIPAA, we're talking about protected health information, which is very broad. It's not only their medical record, it's their name. The fact that they were a patient at your facility. It's their address, it's anything. It's not just patient records, it's any information, any individually identifiable information concerning a patient, their health care, or payment for their health care that could reasonably be used to identify the individual, okay? So let's talk about some of the exceptions then. So the first one is general rule, you can't use or disclose it unless you've got the patient's HIPAA compliant authorization. That HIPAA compliant authorization has to have certain elements in it to be valid, all under 45 CFR 164.510, or 508, which I'm sure you're all familiar with. So there's another exception though. You don't need the patient's authorization if the use or disclosure is for purposes of treatment, payment, or certain healthcare operations. That's the one that applies to most of you, right? Most of your uses or disclosures are for purposes of treatment, payment, or healthcare operations. For those, you don't need the patient's authorization. Now, if you tell the patient we won't disclose your information unless you authorize us to, then you can't do it. You place a limitation on your ability to use that for treatment, payment, or healthcare operations. So my advice to you is never agree with the patient to place restrictions on their use or disclosure for treatment, payment, or healthcare operations. There's a limited exception to that, is the patient can tell you not to make disclosures to payers if the patient pays for their episode of care themselves. But that only comes up if the patient brings that up, so don't bring it up and they won't know and then you don't have to worry about it. Now there's another very important exception to this that applies to all of you. And that's because there's an exception for psychotherapy notes. You cannot use or disclose psychotherapy notes for treatment, payment, or healthcare operations without the patient's authorization. Now the key there is understanding what psychotherapy notes are. Psychotherapy notes are not mental health records. Psychotherapy notes are not progress notes. Psychotherapy notes are not bills. Psychotherapy notes are essentially those notes that you might take for yourself and your own use during the psychotherapy session that are segregated and separate from the rest of the medical record or the mental health record. Those notes from that session that you used in order to generate those other records, those deserve ultra protection. Really the only thing under HIPAA that gets ultra protection. Okay? Those get ultra protection, and you cannot use or disclose those to others, even internally, without the patient's authorization, with very, very limited exceptions. So if you are going to protect or use those psychotherapy notes, if you use psychotherapy notes in generating the records, make sure that those are separate from the rest of the medical record and that they are not used or disclosed along with the other medical records. But for just their, the run-of-the-mill, their mental health assessment and all of those types of stuff, that doesn't get special protection under HIPAA. It's treated just like any other medical record. Okay? A question was, how about a PO? Oh, so the question is, what about a parole officer? Parole officer says they don't need an authorization, they don't need a request for information in order to access their information. And by golly, they're parole officers, so they get whatever they want, right? No, hell no. Not only no, it's a hell no. Okay? No, you're right, they don't. We'll talk about some of these exceptions in just a minute. But no, they don't get it just because they say they do. And by the way, if you haven't guessed already, parole officers and law enforcement don't really care too much about HIPAA. They want to get their information, and they really don't care how they get their information as long as it's going to be admissible in court. And so they'll pretty much tell you whatever they want to say in order to get, and they may threaten you with obstruction and everything else, but that doesn't allow you to go ahead and turn over the information. So we'll talk about that in just a second. All right, HIPAA would allow you to disclose information to personal representatives without the patient's authorization. We'll talk about that in just a minute. HIPAA will allow you to disclose information to business associates if you have an appropriate business associate agreement. Business associates are those entities with whom you share information in order to accomplish certain stuff, right? They're performing certain services on your behalf, right? Maybe your billing agent, maybe your attorney in a malpractice case where you have to provide information to them, protected health information, to allow them for you to function. And that's okay. HIPAA says you can go ahead and do that as long as you get a business associate agreement whereby they basically agree to keep all of that information confidential. HIPAA allows you to make disclosures to family or others involved in the patient's care if the patient consents or if the patient's not available, and therefore they can't consent because they're not available. You otherwise determine that it's reasonable under the circumstances and it's in the patient's best interest to go ahead and make the disclosure. And HIPAA would allow you to make certain disclosures for public safety or public government functions. Let's talk about some of those. HIPAA would allow you to make a disclosure to the extent another law requires the disclosure. We'll talk about that in just a second. HIPAA allows you to make disclosures to prevent a serious and imminent threat of harm. HIPAA allows you to make certain disclosures for public health activities like to the Board of Medicine or to the Board of Social Workers or Board of Psychological Examiners to the extent that they're investigating your licensure, things like that. It would allow you to make disclosures there. For health oversight activities, for certain judicial or administrative proceedings, if you have a court order or warrant or a subpoena and you jump through some extra steps, or you can take disclosure to law enforcement, including parole officers, but only if you satisfy certain conditions. That means that they would have to have some kind of administrative warrant. They'd have to have a warrant or some other exception that would allow them to get the information. Some of those exceptions are things like to locate a victim or a fugitive, or there's several others that may apply, but it doesn't mean that just because they show up in blue that they're able to get the information. General rule is no, we'll need a warrant or we'll need you to identify another HIPAA exception that would allow you to get that information.
Yeah. We have a question from Megan, and she says, what about for clinician supervision? Does all of this apply?
For clinician supervision, I may need to understand. So are we talking about a mental health care provider they're sharing the information with a supervisor? Yeah, then you could go ahead and do it because that is either for treatment purposes or it would be for healthcare operations. And as long as you have not told the patient that you're not going to make those disclosures, remember the rule is that you can use it for treatment, payment, or healthcare operations without the patient's authorization. Okay? All right. Now, let's talk about some of the, another question. While we're waiting for the mic, I will do a little tap dance.
Back to where you had said subpoena, can I just ask a question really quick about that?
Sure. Questions about subpoenas?
Yes. So we often receive these because we see children and divorced parents a lot.
Sure.
When we receive a subpoena, are we required to answer a subpoena if it's just from an attorney, or
Okay.
or do we have to answer that one, or?
Yeah, so here are the rules
Yeah.
when it comes to those situations, okay, when it comes to subpoenas. So in 45 CFR 164.512 subsection E, it says that you can make disclosures for judicial or administrative proceedings so long as you satisfy certain criteria. So if you get a subpoena or order that's signed by a judge or a magistrate, then you can go ahead and do that. The theory is that you've had an independent person, an independent judicial officer review it and determine that it's appropriate and you can go ahead and respond. On the other hand, if you just get a subpoena that's signed by an attorney, that attorney isn't independent. They're representing one side or the other, right? And so you haven't had that additional judicial oversight. So the rules say, well, you can't just ignore the subpoena because the subpoena is still valid, so you can't just blow it off or else you might be subject to contempt. But neither can you produce the information unless you jump through some additional hoops. Generally, it requires you to get written satisfactory assurances from the party that issued the subpoena that they have notified the patient and the patient has either they've notified them of that and the patient has either brought their objections and that those objections have been rejected, or that they've gotten a protective order in place, or here's the one that's probably easiest for you to do. You can, in that situation, send a copy of the subpoena to the patient and tell the patient, we're going to have to go ahead and respond to this subpoena by the date stated unless you take action to quash the subpoena. And then if they don't take action, then you can go ahead and produce it. HIPAA says that's fine. The key here is that there's a subpoena, you can't ignore it, but they want to make sure that the patient has a chance to object to it before you turn it over. And so you can either do that by making sure that you get the written satisfactory assurances from the party who issued the subpoena, which is usually a hassle, or you can just simply, what I usually tell my clients is just send the letter and the subpoena to the patient, tell them, hey, you'll have to quash this and let us know before the time, otherwise we're going to go ahead and produce it. And if you do that, then you've satisfied the requirements in 45 CFR 164.512 subsection E. All right?
Okay, thank you.
Okay. If you want more information about that, just Google Holland and Hart, subpoena, HIPAA, and I've got a whole article on that one too. Okay. All right, any other questions about those issues? All right, let's talk. Remember, HIPAA says that you can make disclosures to the extent another law requires the disclosure. Note that it says another law requires the disclosure, not allows the disclosure. Another law must require the disclosure to fit within the HIPAA exception. So under Idaho, what are some of the exceptions or some of the situations where you're required to make disclosures? Well, child abuse, this is an open book test, right? Child abuse or neglect, vulnerable adult abuse, treatment of a patient who is the victim of a firearm or the victim of abuse, or excuse me, a victim of a crime, then you would have to report that to law enforcement. The one that probably is most important for you all, aside from child abuse or vulnerable adult abuse, is the mental health provider's duty to warn. In that situation, you've got an affirmative, it's the Tarasoff case, right? You've got an affirmative obligation to warn the victim, and if the victim's a minor, their parent, and local law enforcement. If, the standard is, if the patient has communicated an explicit threat of imminent and serious physical harm to a clearly identifiable victim, and the patient has the apparent intent and ability to carry out the threat. Okay? That's the standard. Then you have an obligation to report that, and it's not a HIPAA violation. Certain communicable diseases, and then there's others. Okay? HIPAA also allows you to make disclosures to the personal representatives. Why? Because under HIPAA-ese, under HIPAA language, the personal representative, you treat them as if they were the individual. Okay? They were the patient. So because you can always make disclosures to the patient, you can always make disclosures to the personal representative. Not only may you, but you must make disclosures to the personal representative because you treat them as if they were the patient, and because the patient has a right to access your information, then those personal representatives also have a right to access the information. So then the question is, okay, well, for purposes of HIPAA, who is a personal representative? It really comes down to consent. The way HIPAA works is if this person has the authority to consent to the health care for this person, this other person, then they are the personal representative for purposes of HIPAA. If that person does not have the authority, if the patient can consent to their own health care, then that other person is not the personal representative. So be careful about allowing minors to consent to their own health care, because what you're basically saying is, okay, then the parents are not the personal representative. And that means you can't make disclosures to the personal representative, at least under this exception. And you may have trouble getting paid, although that's another issue. So in Idaho then, the question is, okay, who can make healthcare decisions for another? Well, that's that hierarchy that we talked about earlier, right? You would start at the top and go to the bottom. So may you make disclosures to a court-appointed guardian? Sure. If the person can't consent to their own healthcare, you can make disclosures to the guardian. If it's a minor and the minor can't consent to their own healthcare, you can make disclosures to the parent. Okay? So the authority to consent also means the authority to make disclose information to them. Makes sense, right? They need the information to make healthcare decisions anyway, right? Wouldn't make much sense. Yeah, you got the authority to make healthcare decisions, but we can't give you any information. That wouldn't work out very well. All right. Now, there are certain exceptions that would say that you don't have to treat that personal representative of the individual. Okay? So you can refuse to give the information to the personal representative. These are very limited circumstances, but if the minor has the authority to consent to their own health care, well, then that parent is not the personal representative because the minor can consent to their own health care. That parent doesn't have the authority to make health care decisions for him at that point. So they're not the personal representative. If the minor obtains care at the direction of a court order or a person appointed by the court, that doesn't happen very often. If the parent agrees that the provider may have a confidential relationship. So it may be, if you're providing care to minors, maybe you get the parent to consent that, hey, in order for us to be effective, the minor's got to be able to make disclosures to me and know that I'll keep that confidential. Because they're not going to make disclosures to me if they know that I either can or am required to turn around and disclose it to you. And so you can get the parent to consent up front that, yeah, you can treat that confidentially. And if you do, then that would be an exception. You don't have to treat the parent as the personal representative and make those disclosures. Or if the provider determines that treating the personal representative as the patient is not in the best interest of the patient, like, for example, you think that the minor is being abused by the father, then I'm not going to make the disclosure to the father because we think that that's not in the patient's best interest and could jeopardize them. In that situation, then you can refuse to treat the parent as the personal representative. All right, that is a quick summary of the use and disclosure rules. Any questions about any of those before we move on? A question. Somewhere back there in the back, my old eye, okay, they're waving back there.
It is. So my question is, with the release of information and a consent when they fill out their intake paperwork, I just wanted to know if I kind of went overkill when I was creating the intake packet. And under Title 16, Chapter 24, 16, 24, 28, it says that no person in possession of confidential statements made by a child over the age of 14 years in the course of treatment may disclose any information to the child's parent or others without the written permission of the child. And so I added that as part of the consent to treat, that the child has to sign over permission for things to be discussed with their parents.
Yeah, to the extent that there's another state law that's more restrictive than HIPAA, then you would want to go ahead and include that in there. And now, Title 16, that's the child's mental health care, that's the Department of Health and Welfare, that's the Child Protective Services, all that type of stuff. So it would be a relatively defined set, right? Because it would only be those kids that are under the care of DHW, right? And in that situation, I think that you would probably, I would follow the more restrictive state law in that situation. Okay. All right. Any other questions? Any other questions about HIPAA, confidentiality? Yes, sir.
I actually have a bit of a two-part. The first one being that psychotherapy notes are not the actual the note of a session in the record. Is that correct?
Psychotherapy notes are defined as notes that are kept separate that are generally used to prepare the other records, right? It's the notes from actually the actual psychotherapy session, but not like the mental health assessment or those other things that would appear in the medical record. That is correct.
My other question is exceptions to HIPAA. We often reach out to individuals we may or may not have a release to when the client is suicidal or gravely disabled, and that would be something we'd be okay doing, and how would we document that?
Sure. So in that situation, remember, you still need an exception that will allow you to do that, but is there an exception under HIPAA that would allow you to make those disclosures? Sure. To the extent that it's necessary to avert serious and imminent threat of harm, then you rely on that exception. To the extent that it's a duty to warn situation, you could rely on that one. That one probably doesn't apply in that situation. To the extent that there's another law that requires you to make the disclosure, you may rely on that situation. But usually it's going to be, or treatment. If you're reaching out to another healthcare provider in order to help get that kid care or that patient care, then it's probably for treatment purposes, and therefore you could go ahead and use that exception. Okay? Any of those?
We have a question from Michaela who says, what about confidentiality and client-created art?
Client-created art? Well, client-created art, that is a new one. Kudos to Michaela for giving me a new question. But to the extent that it's not individually identifiable, the art itself is not individually identifiable, then it's not going to be protected by HIPAA anyway. So
it's a part of the psychotherapy note package, though.
Okay, but still, if that document itself, that art itself, does not contain any protected health information, it's just a picture, and nobody could use that to identify who the patient is, then it's not going to be protected by HIPAA, maybe protected by copyright or something else like that, but it's not going to be protected by HIPAA. To the extent that it does have the patient's name or other stuff on it, if it is individually identifiable and relates to the patient's healthcare, or payment for their healthcare, then it would be subject to HIPAA. And you'd need to, same rules would apply.
Thank you.
Okay. Yes, ma'am.
When we're talking Title 16 and the protections afforded to the kids in health and welfare, does that include all Medicaid kids?
I do not know that for sure.
Okay.
I think that it would probably include a lot of the Medicaid kids, but I don't know whether it includes all of Medicaid kids. I think that it would be those kids that have been, I think that aren't there certain processes that they have to go through in order to trigger the Title 16 for, to get the health and welfare responsibility to provide those services? I think there's steps that they go through. I don't think
I've
it's just
always
because
been taught in the state of Idaho, kids over 14, no matter whether they're with health and welfare or not, you shouldn't give their information out like they have adult coverage from HIPAA.
Yeah, I don't think that that's necessarily the case. I think that there is a lot of, there's kind of a general, it would be sexist to say a wives' tale. There's kind of a general thought that because kids who are over age 14 can consent to their own treatment for health care, or for mental health care, for hospitalization for mental health care, there's an assumption that if they're over 14 that they can consent to their own mental health care. And therefore, if they can consent to their own mental health care, then you cannot disclose the information to the parents as the personal representatives unless you fit within another HIPAA exception. Now, if you fit within Title 16, that particular section that was cited back here, then that may be something else, but that would only apply to those who fit within the scope of that particular section. But I do not think under the current law, as you know, I've been doing this for 20 years and no one's ever been able to point me to a different law. I don't think that it's really clear that just because a minor is 14 that they can necessarily consent to their own health care, nor can you disclose their information to their parents. In fact, that would be contrary to a bunch of the other statutes we talked about, right? Even in the hospitalization situation, if they're underage, if they're under age 16, then you've still got to disclose tell the parents that they're there. In the case of shelter care, you still have to get patient parental consent in order to provide the care in the shelter care situation. You know, if the kid wants to leave or the parents want to refuse care, the parents have the authority to refuse care. So I think that just saying blanket that you can't disclose information to the parents if the kids are over age 14, I think that's probably too broad. Again, unless there's another statute that you can identify that says that, but I'm not aware of it. Okay. All righty, another question. We are going to have a hard time getting to that other stuff, which is completely fine.
So as far as consent goes,
Sure.
when you work in an agency and say a client is transitioned from another clinician to you,
Okay?
but they gave informed consent initially,
Okay?
are we still covered by that?
Okay, so let me make sure I understand the question. We're talking about consent for treatment, or are we talking about consent for disclosure of records? Or?
Sorry, consent for treatment.
Okay, so kid got, or there was patient, not necessarily a kid. Patient gave consent at prior facility. Do you need to get new consent? Well, have the circumstances changed at all such that in order for the person to get truly informed consent, you would need to get consent for him? Well, I don't know. Does it make a difference who the healthcare provider is? If you were going to go to a doctor, do you care who the doctor is that you're going to go to? Does it make a difference who it is? Most of us would say yes.
If they're under the same roof
Okay.
and they're in the same practice,
Okay.
it's
I
common
think,
for them to see
right. So here's the
different
rule.
providers.
Here's the general rule, right?
Okay.
If there's any factors that your colleagues would say, yes, that's something that if we're going to that's the type of information that I would want to give to the patient and let the patient make an informed decision. And I think most people would say, and in most of the cases that have come out, one of the important factors is who the treating provider is, because it may make a difference to the patient whether it's you or whether it's somebody else. So as part of the informed consent, you would normally want to make sure that, that they're consenting not only to care, but care by this particular agency or this particular provider, okay? So I think if it were me, I would want to make sure that I get consent when they come into my facility or my organization from any other organization.
Okay, but within the same organization.
Within the same organization, it may not be as big a deal, but I would want to look at the informed consent that was given to make sure that it covers that, and I still would probably want to talk to the patient and make sure that they feel comfortable with it. Because, I mean, for most of your patients, it probably makes a difference who the therapist is. Don't they care? Yeah.
Sure.
Sure. And so in that situation, I think that you'd probably want to do that. Now, the fact that they agreed to come in there and see you and they sit down with them, well, that's implied consent anyway, right? So it's probably not a big deal, but you'd still want to, if you really wanted to be safe, you'd want to document it. Okay?
Thanks.
Good question. All right. Let's talk briefly about the HIPAA security rule. Everything we talked about was the privacy rule that really talks about the confidentiality of the stuff, but there's also the security rule out there. The security rule governs electronic protected health information. And the security rule says, hey, we know that we're going to so much electronic information, we're concerned about maintaining the confidentiality, the integrity, and the availability of that information. And therefore, as part of HIPAA, for any electronic protected health information you store, you've got to comply with the HIPAA security rules, which is all designed. That's those policies about administrative, technical, and physical safeguards that you put in place to make sure that you've got that information available. You've got to do a periodic risk assessment in order to make sure that your data is protected, and you've got to execute appropriate business associates agreements. All of those are all part of the security rule, and you've got to comply with that security rule as part of HIPAA. This is really, really important these days, not only from a patient confidentiality, but just simply because there's so much in cyber attacks and hacking and that type of stuff out there right now. If you're subject to a hack and you lose all of that data, or somebody gets into your records and finds out about your patients, and they can, word gets back to the OCR, and the OCR comes in and investigates and says, well, let me see your security risk assessment, or what kind of security protocols did you have for your system? And you say, well, we never got around to it because we were really busy. Hey, that's willful neglect, right? And you can get hit up with the penalties. More importantly than that these days is really just the threat of like ransomware and crashing your system. Imagine, you guys know what ransomware is, right? That's where they go in there and lock up your system so you can't access. How are you going to function if you can't access any of your patient records? You can't bill for it. You don't know what's going on with your patients. I mean, how can you function? That's why you really need to comply with the security rule, because the security rule is designed to help protect against those types of risks. And the government has been very clear that, look at you healthcare providers, we want to make sure that you are complying with this to protect your electronic information, right? In fact, the director of the Office for Civil Rights earlier this year, she sent out a memo to healthcare providers. All healthcare providers, make sure that you're complying with the security rule, including your periodic risk assessments and the like. They've published a lot of data and a lot of help guidance to help you comply with the cybersecurity stuff. So just, if you're in charge of IT, or go back and talk to your IT folks and make sure that you guys are HIPAA compliant. It's really something you need to do these days. There are certain other things that HIPAA allows for, including HIPAA requires you to give out your patients a notice of patient privacy practices, right? That's that document you have to give to each of their patients as they come in. You have to give them that notice of privacy practices. As I mentioned, patients have a right to request restrictions on their use of disclosure of protected health information for treatment, payment, or healthcare operations. But guess what? You don't have to agree to that. If you do agree to that, then you got to abide by that agreement, and you don't ever want to agree to that because you want to be able to use their information for treatment, payment, or healthcare operations. So don't ever agree to that. A patient has a right to request receipt of communications by alternative means or at alternative locations. So if they say, hey, I want you to send my records to me in a sealed envelope without a return address to this particular address, then you got to comply with it. Okay? A patient has a right to access their information. This is really important. Right now, the Office for Civil Rights has a task force that's working on patient access information. Just remember, general rule is a patient has a right to access their protected health information. Because the personal representative has the right to the same rights as the patient, then they also have a right to access that information unless you fit within those exceptions that we talked about earlier. If you fail to grant that access, then you could be liable for HIPAA penalties. And there's limits on how much time they get and different things like that. I'm not going to go through it right now. Just remember that the exception to that is psychotherapy notes. Psychotherapy notes should be kept separate from the rest of their mental health record or behavioral health record, and they are not entitled to access psychotherapy notes. Patients have a right to request an amendment of their health information, but you don't have to grant it if the information is otherwise correct. And a patient has a right to receive an accounting of disclosures that you've made of their health information. Not all of your information. Basically, it's only those errors that you made when you gave out the information improperly. A patient has a right to come to you and request an amendment of that, or an accounting of that. Let's talk briefly about breach notification, and then I will end up. Remember that under HIPAA, you have an affirmative obligation to narc on yourself if there is a breach of unsecured protected health information. Unsecured protected health information really effectively is just electronic information that is not secured. Okay? So if it's encrypted, it is secured. If it's not encrypted, it's not secured. So if you have a breach of unsecured protected health information, then you've got an affirmative obligation to notify the individual. You've also got to notify HHS and you've got to notify local media if the breach involves more than 500 persons, right? So you've got to narc on yourself. The key here is knowing when there's a breach. The breach is defined as the unauthorized access, use, or disclosure of protected health information in violation of the privacy rule, not the security rule, the privacy rule, unless you can determine that there's a low probability that the data has been compromised by evaluating 4 factors, including who got the information, what kind of information they got, did they actually access the information, and your mitigating factors. Okay, so if you've had a breach, you go through that analysis and you determine whether or not it's reportable. If it's a closed case, go ahead and make the report, because the government really is not actively enforcing HIPAA because they get so many breaches and everything else. They haven't got the time to do it. So unless it's a pretty egregious situation, you're safer just go ahead and do the report, because chances are it's not willful neglect, but if you consciously refuse to make the report, that's probably willful neglect, and they can jump all over you with those additional penalties, okay? All right, my time is up. I am going to turn the time over to my colleague, Ali Schellender. She's going to talk about some other issues. We didn't get to some of these other issues, but in the materials, I think you've got access to the PowerPoints. You've also got access to those articles that I provided to you. It covers the additional stuff, but we covered the fun stuff anyway, so. All right, thank you very much. Ali, it's all yours.
Okey-dokey. Thank you. All right, is everybody ready? I'll be the last speaker here, so you guys can cheer at the end. So like Kim said, my name's Ali Schellender. I am a corporate healthcare attorney at Holland & Hart. I am learning from Kim. So occasionally I may turn to Kim for a little bit of guidance if you have a question outside of the scope of my presentation. So what is a guardianship? A procedure whereby a court appoints a competent, suitable person or entity to make legal decisions for another person. Now, what exactly does that mean? Well, we're going to kind of break it down into pieces to see the full scope of that. Who may need a guardian? Person with disability that lacks the ability to make informed decisions about their care and finances. And then we have an incapacitated person. And that is any person who is impaired to the extent that they lack sufficient understanding or capacity, referencing the standard that Kim mentioned earlier, to make or communicate responsible decisions concerning their persons. Now, that responsible piece can trip people up. If I go out and spend my entire paycheck on shoes, that is not a responsible decision, but that does not mean that I'm incapacitated. So incapacitation would be in a hospital, they're not able to talk, communicate, they've got tubes, they're intubated, and that would be considered an incapacitated person. And then we have a child under the age of 18 whose biological parents are unable to provide the necessary care that that child needs. So we need to find the best interest for that child. So who can be a guardian? For an adult, we have a person, any competent person or suitable institution may be appointed as a guardian by the court. And also, any interested person can be appointed as a guardian as well. That could be a family member, an older sibling, or an adult child. Then for minors, it's for the most part pretty similar, but we have a little bit of differences once a child hits the age of 14. So if a minor is 13 years of age or younger, any person whose appointment as a guardian would be in the best interest of the minor. And then once they turn 14, a person can be nominated by the minor unless the court finds that the appointment is contrary to the minor's best interests. So for a guardian for adult, the procedure, it varies, but generally, When a person is seeking guardianship for an adult, they would need to file a petition and a proposed order with the court and must complete the Idaho Supreme Court's online training on guardianships and how to be a guardian. Then the court will appoint an attorney to represent the ward. Then the court will also look to a court visitor to determine whether it's appropriate or whether guardianship is appropriate. Then we'll have a hearing before the guardian is appointed, and that's crucial to understand. It's not, like Kim said, a guardian, when we're talking about a parent or guardian on a form, we're not saying just their father or mother. It has to be appointed by a court of law. And then if the court appoints a guardian, the letters of guardianship will be issued, and more on that in a second. And for minors, a petition and supporting documents need to be filed with the magistrate court seeking appointment of a guardian ad litem. So in adult cases, we refer to the guardian as a guardian, and in a minor case, we refer to the guardians as a guardian ad litem. It can get a little tricky because a guardian ad litem in an adult's case typically means the attorney for the ward. So that's why I didn't use that language earlier, but there is a distinction in case you guys hear that language elsewhere. Then the guardian ad litem must complete the same training that the adults had to do, which is the Idaho Supreme Court's online training on how to be a guardian. And then the court will provide notice of the place and time of the hearing to a minor, if they're 14 years or older, to the guardian ad litem, and to the parents of the minor, at least 60 days, and also any living grandparent of the minor if they wish to be an interested party in the case. More on that in a second. And then with the appointment, the court is only in a minor case going to make an appointment if it's in the best interest of the child. And if it is, and the courts find that it is, then a guardian will be appointed. So what's the importance of the letters of guardianship? Well, that's the guardian's authority ticket. It's the proof of the appointment by the court and an authority to act on behalf of the ward. So this is something that will be submitted if a guardian is looking to gain some insight from a mental health care professional or a physician. And talking with them, that's the form that they would get along with the signed consent, saying that they are able to talk to that guardian. And the letters specify the powers of the guardian and then any limitations on the powers. So generally in adult cases, and even sometimes in minor cases, but it depends on the circumstances if the child's older, but typically in adult cases of guardianship, there can be there'll be no limitations on the powers, and then there could be some limitations. So let's say maybe the guardian gets to keep their choice of their education if they're in a program, but they need their health care and their finances looked after. That's an example of some of the limitations that a court can put in those documents, but it is important to read those letters because it will tell you exactly what you can give them, what they have authority to read, and so on and so forth. So back to the powers and responsibilities. The guardian's rights are much like that of a parent of a child, and that can sometimes throw people off a little bit because they can do everything else that a parent would be, but they don't actually provide the funds. They don't take money out of their own pocket to pay for clean clothes or housing or food. And then the guardian also takes care to ensure that they have a safe place, medical care that they need, transportation to appointments, which is especially important, clean clothes, and then proper nutrients. And it's important to note, even though you aren't paying for the wards, if you're a guardian, you're not going to be paying for their care out of your pocket. If the ward's assets cannot cover the cost of court fees, that responsibility generally falls on the person that's seeking the guardianship. And that's kind of an important thing to know, and that's kind of where that distinction comes in, is when you're actually making that petition to the court. If the ward doesn't have enough money, or there's no money available, or you can't access their accounts for whatever reason, if you don't have that conservatorship appointment, then that means that that the court fees, sorry for a second. So that means that you would then have to pay during that petition. And it's generally a small fee. I've seen anywhere from 20 to 90 bucks. It's really not too bad. But that's a point where a guardian would have to take money out of their own pocket if the ward's assets aren't available. And then a guardian generally does not handle wards or minors' finances. And if they do, that means that in those letters of guardianship, the court has given authority of both a guardian and then a conservatorship. And the conservatorship is the finances. They're the ones who can access the account, create trusts, do whatever they want, well, not whatever they want, within limits, but control the finances of the ward. And a guardianship is everything else, the care, the food, the clothes, and a judge can, in those letters, make the guardian both a guardian and a conservator. And that means that they can do everything that the guardian does, plus have control of the finances. And then a guardian, one of the most important duties, and why we have guardians, especially for incapacitated persons or minors, is that the guardian is the one who is updating all interested parties. And that includes the court, and also the parents, and any district attorney that is representing the parents in the case of a minor. So let's go quickly over your guys' legal duty to report and when do you need to step in. So who has that duty? Any healthcare provider, including physicians, nurses, medical examiners, dentists, osteopath, podiatrists, the list goes on. And that also includes home care workers. Also, any employee of a public or private health facility, and any social worker or police officer. Any employee of a state licensed or certified residential facility serving vulnerable adults. Those all have a duty to report whenever they have reasonable cause, that's the standard, reasonable cause to believe that a vulnerable adult is being or has been abused, neglected, or exploited. So who do you report to? In the case of adults, it's the Idaho Commission on Aging. And in the case of minors, it is the Child Protective Services, generally. So what if you don't report? Failure to report is a misdemeanor. So like Oprah, the court will just hand out misdemeanors all day long. What if the guardian's not fulfilling their duties? And we get this question a little often, or at least I have, when it comes to guardians. What can you guys do if you're evaluating the ward or the minor and you feel like there's something off with the way that the guardian is representing and protecting, or supposed to be protecting, that ward? You can file a complaint with the court. And that complaint form can be found on the Idaho Supreme Court's website. And I've got the link at the end of this presentation. And it's a pretty short form, but you need to make sure that you have the case number that's affiliated with that guardian's appointment. Without it, it just kind of goes into a deep black hole, especially if you spell a ward's name wrong. But that information can be found on the iCourt portal, and that link is also at the end of the presentation. And in that complaint form that you will submit to the court, that includes any prior notifications or reports or complaints that you made to any other authorities. For adults, the Adult Protective Services for the Idaho Commission on Aging. It could be law enforcement. For children, it could be the Child Protective Services, the AG's office, any type of licensing board if that person is licensed with a professional board. But How long does this guardianship last, though? What if you make a complaint and nothing comes of it, or it's not really addressed? Well, it depends, but sometimes with adult cases, when the ward dies, when the minor reaches the age of majority, which is generally 18 years or older, and if the ward's health significantly improves and no longer needs a guardian, the ward or any interested person may request termination from the court. And with the ward, that generally involves having a mental health professional that is providing a report to the court, or a physician providing a similar report, and they come in and they are asking the court to do this. So then the court looks at all of the reports that you guys have submitted, and then the ward has an opportunity to question the witnesses. And the witnesses would be the people submitting the report. That would be the guardian, any type of physician that was asked to be a part of the case or appointed to the case, including any type of mental health professional, counselor, a psychiatrist, that sort of thing. And these are the resources I was talking about with, and you'll be able to click the link once they're up on the presentation or on the website. But for Ada County guardianship of minors, that page can be kind of confusing to navigate, but if you scroll down a little bit, you'll be able to see a list of all the PDF forms if you check appointment or termination of guardianship. And then there's the information to find the court number that you'll need in order to complete the complaint form to the Supreme Court. And that is what I've got. Yes.
Thank you. For kids who have guardians, well, have parents in prison, clients, I have kids worried that it will take their parents' rights away as their parents because now they have a guardian. Is that true? Like, are the parents still allowed to make decisions for the kids?
So their parental rights are not terminated during the time when there's a guardian involved. And when a parent or when the parents go into or are incarcerated for any reason, then their children, if there's no family member to care for them, sometimes when there is a family member to care for them, then they go into the Child Protective Services. And then that's what kind of starts the process of getting the guardian ad litem, which the guardian ad litem, I forgot to mention, in minor cases, it's done through your Ada, like any county's family advocate or guardian type thing, but through that program, they appoint the guardian. And the guardian, while they have similar powers and rights over the child, the parents' rights haven't been terminated. And that's an important distinction because when they're in prison, there's really not much that they can do from that standpoint. I mean, when they have visitations, of course, they can talk to them, but they can't provide those needs, and that's why the children end up in Child Protective Services in the custody of a foster, or hopefully there's another family member involved. But no, their parental rights are not terminated. Now, if we get far enough along and it looks like the parent, I had a case that I was representing a guardian ad litem in a minor case, and almost this exact scenario happened, where the parent was incarcerated and she had been in there for a couple of years. And the parent did not want to go through adoption proceedings. So this custody case was left open with the magistrate court. So then the guardian just had to keep going and making visits to the home and meeting with any type of healthcare professionals to get their input and then submit that report. And they did that. She'd have to do it on a 6-month and an annual basis for about 3 years. And they kept asking if, because she had more time to her sentence, about 15 years, is 15, 18, somewhere in there, if she had thought about terminating her parental rights. And generally in those situations, the court really does not want to separate a child with their parent, especially if there's a shorter sentence. But in that case, it's still open. The parent had no control over the child at that point, but the parental rights were still there. But after a couple of years, and right now it's actually heading into, the mother decided to terminate her parental rights. So in those situations, generally a court will not force a termination hearing and force the termination of parental rights. But in the cases where the parent thinks that it's probably best, especially if they were incarcerated when their child was very young, then the court will go along with that and start the termination of parental rights hearing and then move towards adoption.
What if the imprisoned parent disagrees with the choices made by the guardian?
Sorry, could you say that one more time?
What if the imprisoned parent disagrees with the choices made by the guardian?
So in that case, it would be what's in the best interest of the child, and the court has determined that that guardian, if there's no complaints against them and they're fulfilling their duties and obligations under the law, then the parent would get trumped in that scenario. But it's not like it wouldn't be considered, because most likely it would move to a hearing or be scheduled for a hearing for the parent to express what the concerns are, and then it's kind of more of a negotiated point. When the case is still open for Child Protective Services, it's pretty flexible. It's not like a regular trial. You're not there yet. You're kind of just negotiating and trying to get the parents on the right track so that we don't have to go to a termination. A judge does not want to terminate parental rights. It's a constitutionally protected right. So that's why it's such a big burden to actually terminate. But yeah, if there's a disagreement and they're incarcerated, generally the guardian will be correct or will have that authority, but that doesn't mean that the incarcerated parent can't call for a hearing to discuss that issue. And generally then that judge acts more as a mediator in that sense, especially since it's not a formal proceeding. It's literally just a conversation, and you've got your guardians. Sometimes healthcare professionals pop up there too, and they kind of all give their input. And then the judge, if it's brought to the judge, then the judge kind of makes that decision. Any other questions?
Okay. Allie, thank you so very much. I want to be cognizant of the time. Appreciate your input and time. And your willingness to step away from your practices for a while and come and listen to the speakers that we've brought in. It's very meaningful to us to realize that the people we depend on, that is you, so much, are willing to do so, and so thank you. Be sure to complete your conference evaluation email to provide us with some guidance for our future events. This is a very valuable part of our relationship with you. You can help us make it even better. Also, be sure to complete the surveys for each of the sessions that you attended, because it's contingent upon you getting your CEUs. So if you get those surveys in, those CEUs will, certificates will come to you in your email. If there are any problems with the spelling of your name or what have you, you can address that with a letter or an email to us at optumconference.com, optumconference@optum.com. And finally, if those of you here or perhaps virtually who are not in our network find yourself interested in further relationship with Optum Idaho, you can make that happen on optumidaho.com. We can establish some contact with you if you have that interest. But other than that, thank you again, and travel safely going home. Goodbye now.